This story is about inheritance theft, one of the most underreported forms of family financial abuse. Before I tell you what happened to me, I want you to know that what I experienced has a name, a legal framework, and a documented psychological pattern that affects thousands of families every year. I'm telling it because I spent 4 years not knowing any of that. I'm telling it so that maybe you recognize something sooner than I did. My name is Jess Harmon. I'm 27 years old, and when I was 23, my grandmother left me $120,000. I never received it. My parents spent it over the course of 11 months while I was 2,300 miles away on a graduate internship in Edinburgh, Scotland, trusting them to handle my affairs the way I had trusted them to handle everything my entire life. I want to tell you about my grandmother first because she is the reason the money existed. And because she's the part of this story, I don't want to get lost in the legal details. Her name was Margaret Harmon. Everyone called her Peggy. She was 79 years old when she died in March 2020, a Tuesday morning in a hospice in Nashville, Tennessee, with my father at her bedside and me on a video call from a flat in Edinburgh at 3 in the morning because of the time difference. She had been a practical woman, a bookkeeper for 30 years, careful with money in the specific way of people who grew up without enough of it, and decided early that they would never be without it again. She had a savings account and a small investment portfolio and a house in Nashville where she had lived since 1972. She had a will. She had had a will since 2008, updated in 2017, filed with an estate attorney named Charles Webb, who had handled her affairs for 12 years. I knew she was leaving me something. She had told me directly in 2018, sitting at her kitchen table on a Sunday afternoon, that she wanted me to have money for a real start, for a down payment, or to pay off loans, or to do something that would give me options she hadn't had at my age. She said she was leaving equal amounts to my father and my Aunt Patricia, and that she was leaving me $120,000 separately, specifically because she wanted it to be mine and not absorbed into someone else's household. She was precise about this. She used the word separately twice. I remembered it. When she died in March 2020, I was 4 months into a 12-month graduate research internship at the University of Edinburgh. The timing was brutal in the specific way that timing is brutal when there is nothing to be done about it. I flew home for the funeral. 4 days, Nashville, back to Edinburgh. My father handled the immediate arrangements. He told me the estate would take several months to settle, that Charles Webb was managing the process, that I should focus on my work, and he would keep me informed. I said okay. I flew back to Edinburgh. I focused on my work. I trusted my father to keep me informed. He kept me informed in the way of someone providing the minimum information required to prevent questions. Monthly texts. Estate is in process. These things take time. Webb is working on it. I did not push. I did not ask for documentation. I was 23 years old, grieving, 6 time zones away, in the middle of a demanding research program, and I had spent my entire life in a family where my father handled things, and handling things meant they were handled. I did not yet understand that trust and verification are different practices, and that I had been taught only one of them. I returned to Nashville in March 2021. 12 months abroad, internship complete, master's degree finished, moving back to figure out the next step. I moved into my parents' house temporarily, a plan that was supposed to last 3 months and lasted 6 because the job market was difficult and Nashville was expensive, and my parents said, of course, stay as long as you need, which I now understand differently than I understood it then. The inheritance did not come up immediately. I assumed the estate was still in process. These things take time, my father had said repeatedly, and I had no reason to disbelieve him. In May, I asked directly, Dad, where are we with Grandma's estate? He said Webb had run into some complications with the property, that the house had needed repairs before it could be sold, that the funds were tied up in the process but would be resolved soon. I said okay. I got a job in August, moved into my own apartment in September, and the inheritance receded into background noise, something that was coming, that I would deal with when it arrived, that my father was handling. It did not arrive. By March 2022, 2 years after my grandmother's death, I had not received anything. I asked again. My father said there had been tax complications, that Webb had retired, and the file had been transferred to a new attorney, that these things sometimes took longer than expected. I said I would like to speak to the new attorney directly. My father said he would arrange it. He did not arrange it. I asked twice more. Both times he said he would follow up. In September 2020, I found the will. Not through investigation, not through any deliberate action. I found it the way you find things you weren't looking for. I was helping my mother organize a storage closet in their house, the kind of task that happens on a Sunday afternoon when you are visiting and there's nothing particular to do. And in a box labeled Household Documents, there was a manila envelope with Peggy Estate written on it in my father's handwriting. I put it in the box I was sorting. Then I took it out. Then I opened it. Inside was a copy of my grandmother's will, a copy of the estate inventory, and a document I recognized from my research background as a final distribution statement. The accounting that closes an estate and records where every asset went. I read the distribution statement. The estate had been distributed in full in February 2021, 11 months after my grandmother's death. My father had received his share. My Aunt Patricia had received hers. Under my name, on the line that read Beneficiary, Jessica Lynn Harmon. The amount was $120,000, and the distribution method was listed as cash transfer, and the date was February 18, 2021. I had been in Edinburgh on February 18, 2021. I had never received a wire transfer. I had never received a check. I had never received anything. I stood in my parents' storage closet holding that document for a long time. I am trying to be precise about what I felt because I think precision matters here. What I felt was not immediately anger. What I felt first was the specific sensation of something reorganizing itself, a long sequence of events rearranging into a pattern I had been looking at from the wrong angle. The tax complications, the new attorney, the follow-up that never came, the invitation to stay as long as I needed, the 6 months in their house, all of it assembling into a shape I had not been able to see until I was holding a document that made it undeniable. I put the envelope back in the box. I finished sorting the closet. I had dinner with my parents that evening, and I talked about my job and a movie I had seen, and nothing that was actually happening in my mind. I drove home at 9:30. I sat at my kitchen table, and I called my friend Dana, who is a paralegal in Nashville, and who I trust completely, and I told her what I had found. She said, "Jess, don't do anything until you talk to an estate attorney." I said, "I know." She gave me a name. I called the next morning. The attorney's name was Rebecca Cho, an estate litigation specialist in Nashville with 20 years of experience in probate disputes, and what she described, in our first meeting, as a particular focus on intra-family financial abuse cases. I brought the documents. She reviewed them. She asked me several questions. Then she said, "Jess, what you've described is a straightforward case of inheritance misappropriation. The distribution statement shows the funds were disbursed to your designated account. We need to establish where that account was, who controlled it, and where the money went from there." I said, "How do we do that?" She said, "We subpoena the records. The subpoenas went out in November 2022. The bank records came back in January 2023. What they showed was a joint account that had been opened in my name and my father's name in January 2021, 1 month before the estate distribution. The account had received $120,000 on February 18, 2021. Over the following 11 months, the account had been drained through a combination of transfers to my parents' personal accounts, bill payments, a kitchen renovation in March, a car purchase in June, and a vacation to Cancun in October. The account balance on the day I found the will in that storage closet was $412. Rebecca filed suit in February 2023. The case was Harmon v. Harmon in Davidson County Chancery Court. My parents retained an attorney. Their initial position, communicated through that attorney, was that the joint account had been established for convenience and that I had been aware of and consented to the expenditures. I had not been aware. I had not consented. I had been in Edinburgh when the account was opened, and I had no documentation of any communication about it because no such communication had occurred. Rebecca said their defense requires them to produce evidence of your consent. They don't have it because it doesn't exist. The pretrial process took 8 months. Depositions, document production, financial discovery. I was deposed in April. My father was deposed in May. In his deposition, my father said that my grandmother had discussed the joint account structure with him directly, and that Peggy had intended for him to manage the funds on my behalf, given my age and circumstances. Rebecca cross-referenced this with the will, which made no such provision, and with Charles Webb's file notes, which Webb, now retired but cooperative, produced in full. Webb's notes contained no reference to any joint management arrangement. They contained, however, a note from a meeting with my grandmother in 2017 in which Peggy had specifically stated that she wanted the funds to go directly to Jess, separately, without passing through any other family member's hands. She had been precise about it. She had used the word separately. I had remembered it because she had said it twice at her kitchen table in 2018. She had said it to her attorney a year earlier. The case went to hearing in September 2023. 3 days in the Davidson County Chancery Court. I sat at the plaintiff's table and I watched my father sit at the defendant's table. And I thought about March 2020 and a video call at 3 in the morning and the way he had said these things. Take time. And I thought about Peggy saying separately, and I thought about the kitchen renovation in Cancun, and I kept my face still because I had learned over the previous 18 months that stillness was the most powerful thing available to me in rooms where I was not the one in control of what happened next. The chancellor issued her ruling in November 2023, judgment for the plaintiff. My father was ordered to repay $120,000 plus interest calculated from the date of distribution, plus Rebecca's legal fees, plus court costs. The total judgment was $141,800. My father did not have $141,800 in liquid assets. The judgment resulted in a lien on my parents' house and a structured repayment arrangement that will run for 7 years. My relationship with my parents is something I am not going to describe in full because I am still inside it and it is not finished. What I will say is that my mother called me 2 weeks after the ruling. She said she had not known the full extent of what my father had done with the money. I said I didn't know whether to believe that. She said she understood. We have spoken 3 times since. The conversations are short and careful, and I do not know what they are building toward. My father has not called. His attorney communicates with Rebecca on the payment schedule. That is the current form of our relationship, the money. I have received 2 structured payments so far under the repayment arrangement. The total received is $22,000. $119,800 remain on the judgment. I do not expect to receive it all. I have been advised to have realistic expectations about judgment collection when the debtor is a retired person with limited liquid assets. What I have is the judgment itself, which is documented, which is permanent, which says clearly and in the record of a Tennessee court that what happened to me happened and that it was wrong. Peggy would have been 83 this year. She liked crossword puzzles and strong coffee and a specific brand of lemon cookies she ordered from a catalog. She saved money for 60 years so that her granddaughter would have options. She was precise about it. She used the word separately. I am using the word separately now, in this story, for the same reason she used it then. Because some words need to be said clearly and kept on record, separately. It was mine. She meant it to be mine. Before I close, I want to name what this story illustrates, because I think naming things is part of what makes them survivable. What happened to me has a clinical name. Researchers who study family financial abuse call it inheritance theft, and it falls under the broader category of financial exploitation of young adults by parental figures. But the psychological mechanism that allowed it to go undetected for 4 years has a name too. Dr. Jennifer Fried, a psychologist at the University of Oregon, developed what she calls betrayal trauma theory. The observation that when harm is perpetrated by someone we are dependent on or deeply attached to, the mind has a protective mechanism that limits how fully we process the evidence of that harm. We see the signs, we file them away, we find explanations, we trust, we ask the question and accept the insufficient answer. Not because we are naive, because we are human, and because the cost of fully knowing when what we would know is that a parent stole from us is sometimes too high to pay until we had no choice. I paid it in a storage closet on a Sunday afternoon, holding a distribution statement. The 4 years before that were not weakness. They were my mind protecting me until I was ready. I was ready at 26. I wish I had been ready sooner. I understand now why I wasn't. If this story meant something to you, drop a comment. Tell me, did you recognize the betrayal blindness in yourself or in someone you know? I want to hear it. Subscribe. I'll see you in the next one.